where the state in the Senzo Meyiwa murder trial has suffered a setback. Judge Ratha Mokgoatlheng ruled that the audio recording of the accused number 2, being Bongani Ntanzi's audio recording of the confession statement, cannot be accepted as evidence. The judge says Ntanzi's rights were violated when he was recorded without his consent. Now, to help us understand what this means for the state or the defence's case, I'm now joined by Ian Allis, who is a criminal law expert. A very good afternoon to you. Thank you for your time. In the trial within the trial today, Judge Mokgoatlheng handed down judgment on the state's application to admit this recording. What is your take on it? What's your immediate reaction?
Good afternoon, and Paul. Good afternoon to the viewers. First and foremost, one must accept the fact that when a person gives a confession, it must be free and voluntary. And the problem when we're having recordings like this, and especially in the absence of legal representation by an accused, there's always that risk that it's not going to be admissible because of coercion. Like even with regards to a recording can be tampered with, it can be changed, it can be manipulated. So the problem that actually comes with this, and this is why the learned judge is actually saying it's not admissible, is even with parties in there and possibly with the magistrate being in there, that the person was under immense emotional duress or stress, because they don't know, it doesn't disclose how long the person was in interrogation for, what was used to go ahead and exert and obtain that answer and that confession. So that is the reason why often in a situation like that, confessions have got, there's very serious manners in how a confession must in actual fact be made to show that it was free and voluntarily obtained.
Yeah, as you say that, and as the case is ongoing, what we have been hearing is that Ntanzi denies initialing every single page of the confession statement, and also Cronje saying that he was well composed, he was calm, he appeared to be relaxed, and that his handcuffs even were loose, and describing them to almost look like they were bangles on a woman's hands. Would you say this was an outcome that could have been preempted, especially because Advocate George Baloyi had argued very strongly that Ntanzi's rights were not violated, contending that the recording was effectively an electronic version of what Ntanzi had told the magistrate, so there was no room to argue his rights to privacy were infringed?
It was preempted. That's the reason why they had to, that they would so vociferously arguing those exact points, because they knew this would become something that would come up for scrutiny, especially with the defence raising the issues of that confession and the statements and the initialing, and who wrote out the statement and the time and how long the person had been interrogated for. So the reality is that in any confession, in the absence of that party being legally represented, and just even with the presence of a magistrate, will go ahead and raise this prospect that that person is going to say they were under duress, or they were coerced, or they were fearful, or they were intimidated. That is just part parcel of what actually happens after the fact, which is why the state have got to be very careful when dealing with confessions and making sure that it is to the book with regards to the recordings, visual and audio, as well as how the person is presented, and that it ties up exactly with the confession, and that all the necessary oaths are taken for it.
With this ruling granting a slight reprieve for the accused, Ntanzi, the court, my understanding is that the court still needs to rule on the admissibility of the alleged confession statement. What will that process entail?
The problem is it's a twofold aspect, and already with saying that their rights were violated could undermine their admissibility considerably. on that statement being admitted from the evidentiary point of view, because already if the person's making the argument that they were under duress or under emotional stress and intimidated, and that's where the rights violation, it almost becomes the fruit of the poisonous tree in legal terms, is how can you have the admissibility of it when the rights were actually violated in the first place. And to that extent, it might be that there might be certain irregularities which one could overlook and say, yes, maybe you weren't seated in the right position, or that there could have been a problem with the tape of how long it was dated for, but it doesn't go ahead and affect the story. He's saying that his rights were violated, which undermines what his story in actual fact is, or his version, which is the confession.
Yeah. Now, because the recording cannot be admitted into evidence, how does the knowledge of an admission impact the line of argument going further, whether it's for the state or the defense's case?
Well, basically, then that evidence is treated as, it's not that it can't be admitted and cannot be tested. It's just that it has to almost be dealt with that on the facts, that on this day you did say this, on this day you did say that. He's going to, and the accused will have to then respond in how he came up with that version, why he said that, and what he said. So it could still be attacked, but what it just does is it convolutes the aspect of the proverbial slam dunk of saying, well, he's confessed to the crime. Now they're still going to have to prove the elements and go through that statement to use that in cross-examination or any evidence that's going to be given by that witness. So it's going to put him under. It will also then mean that accused, if that confession is not admitted as a confession, it still exists as a statement that they can still use it for cross-examination purposes of why and what and how.
Very well. Thank you so much for your time. Ian Allis there, a criminal law expert, just speaking about Bongani Ntanzi's audio recording of the confession statement to not being accepted as evidence there.